Another option before formal discipline is a corrective order. If the division finds that a licensee is violating specific rules, they may give the licensee a written notice of the violation. They may also give the licensee up to 30 days to remedy the violations. If the licensee fails to correct the problem, the division retains the right to continue pursuing discipline. Please note the division is not required to give corrective notices before pursuing formal discipline. The division may do so at its own discretion. Once the division has completed its investigation, it must decide whether or not to pursue formal discipline. If the division does not feel it has enough evidence to move forward, the case will be closed. If the division does feel the licensee has violated either a rule or statute, the next step in the disciplinary process is to offer a stipulation or schedule a hearing. A stipulation is essentially a settlement agreement between the division and the individual or company being investigated. The division offers a penalty or form of discipline which is usually lighter than the individual might expect if the complaint is taken to a hearing. A stipulation may be tempting to a licensee because of the potential lighter sentence. The licensee takes a chance of receiving a more serious penalty at a hearing if the stipulation is rejected. The division is often motivated to offer stipulations in the interest of efficiency. The division's investigative resources are limited. A stipulation offers a division the opportunity to close out the case without additional expense of time and resources that are associated with the hearing process. If the division offers a stipulation, and the individual being investigated chooses to accept the stipulation is presented to the Real Estate Commission. When the Commission accepts the stipulation, the matter is considered closed. Please note, the division is under no obligation to offer stipulation and does so at its own discretion. Other than the remedies already discussed, namely a cease and desist order, a corrective action notice, or stipulation, the division's options for discipline are very limited before a hearing is held. The division and the commission have the option of holding the hearing themselves or requesting the assistance of an administrative law judge. If the division decides to schedule a hearing, written notice must be mailed to the person for whom the hearing is being held. If the hearing is being held for an associate broker or a sales agent, the division must also notify the principal broker with whom the licensee is affiliated of the hearing. The notice must also be done in writing. As we mentioned, the hearing is usually held in front of the Real Estate Commission. The Commission may be requesting the hearing to be handled by an administrative law judge. Most hearings are technically considered informal hearings. Informal hearings give the division more flexibility in dealing with disciplinary issues. Most issues regarding the granting, renewal, or activation of a license are handled at the informal hearing held by the Commission. Hearings regarding the certifications for real estate schools, license revocations, and failures to disclose criminal backgrounds are also informal hearings held by the Commission. While the hearings are technically informal, the proceedings resemble a court proceeding, with the Commission acting as a panel of judges. The division is represented by a representative from the State Attorney General's office. The licensee may be represented by an attorney or may represent themselves. Licensees are not required to have an attorney present at the hearing. At the hearing, both the division and the respondent or the person responding to the complaint are given the opportunity to tell their side of the story. Witnesses may be called, and information is presented by both sides in an effort to prove their respective cases. Respondents will typically have access to any information or evidence gathered by the division in the course of the division's investigation. As we mentioned previously, the division may subpoena records or issue orders to produce records needed for the investigation. After the hearing, the Commission then renders its decision. The Commission may decide that there are no grounds for discipline against the respondent. If the Commission feels there are grounds for discipline against the respondent, they may choose from a list of remedies. Please note, these remedies are only available to the Commission after the hearing has been held. If the respondent does not appear for the hearing may be held in their absence, and a decision may be rendered. Obviously, it is in the respondent's best interest to appear at the hearing. Once the Commission renders a decision, it is not effective for 30 days following the rendering of the decision. For example, if the Commission decided to revoke a license of an individual on April 1st, the individual's license would still be active until April 30th. If a respondent wishes to appeal a decision rendered by the Real Estate Commission, the appeal may be heard by the Executive Director of the Department of Commerce or may be handled by the District Court. If a licensee does appeal the Commission's decision, they may be able to obtain a stay from the ruling of the Commission. A stay delays the effective date of the Commission's decision until the appeal may be heard. If a sales agent or associate broker is disciplined by the Commission or an administrative law judge, the principal broker may also be disciplined for failing to supervise the activities of the associate broker or sales agent.